India just got a new data protection law and the penalties for non-compliance up to 250 crores. Whether you run a startup, an e-commerce store, or even a small business, with customer data, this law applies to you. And the compliance deadlines have already started. The Digital Personal Data Protection Act 2023, called the DPDP, just got its implementation rules in 2025, and we have strict deadlines coming up. Miss these, and you're looking at penalties up to 250 crores. Let's break down exactly what you need to do and by when. Hi everyone, I'm Parth from Navigate AIF, and we are a legal tech company solving regulatory challenges for AIFs. Today in this video, we are covering India's game-changing DPDP Act and the rules that were notified on 13th November 2025. This law fundamentally changes how every business in India, from startups to large corporates, deals and handles customer data. But here's what makes this video special. I'm joined by Mrs. Aparna Gaur, the founder of Traces Law Partners, who has over a decade of experience in intellectual property, education, technology, media, and telecommunications law. Her expertise has been recognized by Legal 500, which named her a leading individual for IP in 2024 and 2025, and a rising star for TMT. Aparna will walk us through the practical compliance requirements and real world implementation of this act with examples. Aparna, welcome to the channel. Let's dive right in.
The DPDP completely overhauls the privacy framework in the country. It applies to any processing of personal data in digitized form by any organization. Personal data has been defined very broadly as any information that could be used to identify an individual. And this could include your name, phone numbers, email addresses, even information like your financial information, and so on. In the context of AIFs, this is likely to include information of your investors, including KYC data, investment related information, and obviously information about your employees. Now, this law was enacted in 2023, but it is only being implemented now by the government in a staggered manner. Substantive provisions which require companies to sort of change their practices in relation to how they're dealing with personal data coming into effect only after 18 months, which is about May 2027. Now, while 18 months sounds like a long time to start complying with this law, uh, entities will need to take a look at and assess how they're currently dealing with personal data, what personal data they hold, who are they sharing it with, is there cross-border sharing, what are their what obligations are being imposed right now under their contracts with their vendors and so on. And therefore, it is advisable to start these processes now so that within the next 3 4 months you at least know where you stand in relation to your compliances. The law applies not only to processing of personal data within the country but also to processing outside of India if such processing is in relation to provision of goods or services to individuals located within the country. Therefore, it's important to understand how operations are structured to understand which all entities the law is applicable to. Now, it's also, before we get into the compliances, there are certain key terms which are very important to understand. One is the data fiduciary, which is the entity which determines the means and purposes of processing of the data. In terms of AIFs, this is likely to be the investment manager who decides how investor data is being processed. Then comes the data principal, which is the actually the person whose data is being processed. This could be investors, employees, and so on. The third type of entities which are relevant are data processors, which are entities who process information on behalf of data fiduciaries. Uh, so this will include any vendors such as KYC service providers, any IT service providers, and so on. In terms of compliances, it's important to understand that the law allows processing on two grounds. One is consent, and one is specific legitimate uses which have been identified under the law. These are very specific instances where entities can process data without obtaining consent. These include instances where the data principal is voluntarily sharing information for certain specific reasons, or certain employee related processing of information, which we won't deal with today. Um, Other than this, any processing of personal data needs to be consent based unless it's specifically exempted under the law. Uh, Consent under the law needs to be free, specific, unambiguous, and so on. If processing is on the basis of consent, entities also need to provide a notice along with along when they're taking consent or before taking consent. The notice must explain what data is being collected and for what purposes, and certain other information on how rights are to be exercised and so on needs to be provided. There are other very key obligations under the law. Some of them include ensuring that you have reasonable security measures in place. These include so the law doesn't specify what reasonable security measures need to be in place, but the DPDP rules that just came out do identify certain minimum measures that entities need to have in place to ensure compliance. The other one, very important one, is in relation to reporting of personal data breaches. Now, reporting under this law, there is an obligation to report breaches not only to the Data Protection Board, which is the authority being formed under this law, but also to uh, individuals who are impacted by the breach. This is very important because this is the first time in India that a law has come out which requires uh, reporting to affected data principals. Uh, and this is in addition to existing reporting obligations that probably exist under sectoral laws and in relation to cert in reporting as well. Another key obligation is in relation to uh, data processors, which are, like I had explained, vendors of any AIF, say any entity helping with KYC, IT service providers, and so on. In relation to any such vendors, certain obligations under the DPDPA need to be passed down. These include obligations in relation to reasonable security practices, ensuring that any incidents that take place at the vendor's end are reported to the data fiduciary, ensuring that the vendor is assisting the data fiduciary in exercising to ensure that the data principals are exercising their rights. See, there are certain obligations. This is not all the obligations under the law, but these are the key obligations. It's also very important to understand that the law does have a very strict penalty framework. But important aspect is that the penalties are applicable only in case of significant breaches of the law. So not in relation to every breach, but significant breaches of the law. The penalties can be imposed by the board. From a practical perspective, to ensure compliance, the first step would be a data mapping exercise. This means uh, to understand where you are currently with your data practices, what data is being collected, who is it being shared with, is it being shared with entities abroad, uh, what are your retention practices, are you allowing withdrawal of consent, what does your privacy policy look like. And once you have taken stock of all of that, you need to understand how all this needs to be updated to ensure compliance with the DPDPA. Then the next step is obviously implementation, uh, which will require you to overhaul your internal practices, training the relevant teams on how to ensure compliance on an ongoing basis, and having internal SOPs in place for, say, data breach reporting. In what way does retention of data work, withdrawal of consent work, and so on. So these are certain important aspects that entities should now start working towards to ensure compliance within this 18-month timeline.